Yes, we are recording and live now.
There we go. Good afternoon. Welcome to the June 4th Committee of Bar Examiners Subcommittee of Examinations meeting. As a reminder, this meeting is being recorded. At this time, I'd like to request the roll call. Christina?
Okay, Dr. Bolton,
Here.
Bethany Peak,
Here.
Ashley Silva Guzman,
Here.
Judge Reyna,
Here.
Alan Yokelson,
Here.
Alex Lawrence is absent, and Justice Macy Walla is absent, but we have quorum.
Thank you. We're calling this meeting to order. As required by the Bagley-Keene Act, Open Meeting Act, members are to appear visibly on camera during teleconference meetings, except if a member is unable to appear by video due to connectivity challenges. We ask that any members who are present with their cameras off state their name and reason for not being on camera. Additionally, if a member joins the meeting after roll call, they should raise their hand virtually to notify myself and the public of their presence. If their camera is off, they should provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. Next, I heard something, but okay, maybe just me. Next on the agenda is a call for public comment. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the subcommittee exercises oversight of testing accommodations. The subcommittee does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meeting. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the subcommittee would have time to consider these comments. The subcommittee has received and read all written public comments, and we thank you all for those. To facilitate the hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. In light of the fact that the Subcommittee on Examinations is likely to lose quorum at exactly 1 p.m. and is addressing a number of testing accommodation appeals in closed session, recognizing that we have a few pre-existing advanced signups wishing to make public comment, I move to suspend the rule of order to limit the public comment to a maximum of 30 minutes. Do I have a second?
Yes.
Okay. And we can take a vote on that.
Okay, Dr. Bolton,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Alan Yokelson.
Yes.
That carries.
Great. Thank you. If any person who wanted to provide public comment is unable to do so today, we invite these individuals to submit their comments in writing as well. Additionally, as the chair of the Subcommittee on Examinations, I am going to exercise the option to limit each speaker's time to 2 minutes. For those participating by Zoom video, you should have a function for virtually raising your hand. It is the hand icon and should appear at the bottom center of your screen. If you wish to address this subcommittee, please click on the hand icon now, and the committee coordinator will call on you in the order that hands are raised. For those participating by phone, you may virtually raise your hand by pressing *9. That is the star key and then the number 9. Again, doing so will alert the staff that you would like to make a comment, and the committee coordinator will call on you and open your microphone so that you can address the committee when it's your turn. For those participating from a noticed location, please alert the committee member or state bar staff member present if you would like to make a comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. And I believe we have some advanced signups for public comment. And we can get started with that.
We do have one advanced sign up. Benjamin Cohn, your mic has been enabled.
Hello, thank you. I wanted to address the decision of the CBE on May 30 regarding testing accommodation failure to implement issues on the February 2025 exam. The timeline of September 30 to reach a position on whether such incidents occurred, to what extent they occurred, and to even start the discussion, not even the decision of what remedies to seek, let alone get and implement from the California Supreme Court, is not consistent with federal requirements that there be equal opportunity for the particular exam cycle at issue. There are permanent or at least long-reaching consequences to these kinds of delays that are not entirely reparable through the remedy in the extent that they affect professional development or prospects towards future employment that then snowballs out indefinitely. So there is a necessity. It's not a discretionary timing issue of how to handle it to address these things to the extent that you know that there's plausibility or that they happened in a shorter time frame, and not prioritize staff resources in some other way that seems to be consistent with the general attitude that testing accommodation issues are somehow less than other applicants' concerns. So for whatever motivation seems to be causing that, driving that. So this investigation should be expedited. It should produce a decision in time for applicants to be with that issue to receive a decision at least as quickly as on the performance test imputation and other provisional licensure and other remedies that are being still outstanding for applicants generally. And if you can't do that, an applicant has reported that they didn't receive their testing accommodations under penalty of perjury, then I think you're obligated just to credit that attestation absent rebuttal evidence and apply the decide the appropriate remedy expeditiously. And make no mistake, if that failure to implement can't be investigated to ascertain the magnitude, that remedy should be seeking a retroactive automatic pass of that applicant, and compensating them for any bodily injury if the failure to implement a testing accommodation were to have caused such a thing. Thank you.
Thank you, Benjamin, for your public comment. We'll now proceed to members of the public at notice locations. Do any subcommittee members have any interested parties making public comment from their location?
None from Los Angeles.
No.
Okay, and I don't think there's any from Dr. Bolton. So are there any public members of the public who signed up in advance other than Mr. Cohn?
There are no others, but I do see one hand raised remotely when we are ready.
Perfect. We can proceed now to those who have raised their hands remotely.
So Katie Scally, your microphone has been enabled.
Hi, good afternoon. I'm one of the attorneys that has been speaking at some of these meetings, and there's been a lot of talk and discussion about all of these different remedies. And initially, there was a discussion about remedies for attorneys, and there was sort of a back and forth among the committee with bar examiners on, do we even need to do this, or will this other statute, I forget the name of the statute, SB, I forget the 3 digits, will that have already been passed? Is this even necessary? Oh, I don't know, we could try and do it even more expeditiously than this statute. And I walked away from that meeting thinking, okay, this is all set. Like, either the statute is going to happen, and if it doesn't, these bar examiners are going to take care of me, you know, and this statute will probably pass before then. That has not proven to be the case. In fact, almost immediately after that meeting, the wording in the statute was changed. And this has sort of all been pushed under the rug, so to speak, as all these other remedies have been exhausted and, gone back and forth about whether we're going to count the highest score or the lowest score of essays when we have graders that are considered capable, yet we're throwing out the lowest score, whether we're going to change the performance test and this, and it's these minutia of changes that affect 200 people, 135 people. And the idea of the attorneys actually passing has sort of just gone by the wayside. And to me, at this point, if the object, and everybody has agreed since the beginning, was for the attorneys to pass, then it seems that given the number of changes that have been made for the rest of the group, it's not out of the realm of possibility that the attorneys be plucked out and their scores be upped and they all pass. Because it wouldn't be that inconsistent with the other remedies that have been applied to random groups of people.
Thank you for your public comment, Katie.
And there are no more raised hands in the attendees list.
Thank you. So this concludes public comment period. The subcommittee will be performing the rest of our duties in closed session and then return to close out the meeting. Oh, and everyone can exit out of this one. Make sure you're exited out and join the closed session meeting. Thank you.
How are you?
Hey, I believe everyone's back, mostly. And the subcommittee has concluded their items on the agenda today. Oh.
Ashley, are you still there? Jean, if Ashley is having technical difficulties, can I adjourn the meeting or?
One of our members can, and I might suggest that it's Alan since he.
There we are. Thank you.
Alan, we lost Ashley, it seems. Would you mind closing out our meeting?
Sure. With no further business before the subcommittee, I declare this meeting closed. Thank you, everybody.
Thanks,
Thank you
everyone.
all for your
Thank you.
time.
Thanks.
Oh, there's Ashley.
Apologies for that. I lost my service, I think. There we go. Okay, I was just saying that we had handled all of the business in closed session, and with that, we're adjourning the meeting for today. Thank you all for your attendance.
Thanks.
Thanks, everyone.
Thank you.
Thank you.